This is Colin O'Keefe for LXBN TV. Today we're discussing Sackett v. EPA, a Supreme Court case that could have a huge impact on the EPA's authority. Joining me today is Seth Jaffe, a partner at Foley Hoag and author on the firm's blog, Law and the Environment. Seth, starting here with the basics, can you walk us through the case and exactly what's at stake here?
Sure. Sackett, it's actually a husband and wife, and it's a fairly typical fact pattern for these types of cases, particularly cases for EPA's order authority under the Clean Water Act. They had a part of a residential subdivision, and they graded it to build a house, and the next thing they knew, EPA had said that they had illegally filled wetlands, and they issued them what's called a unilateral order, telling them that they needed to fix it, basically. What the case is about is whether, in fact, EPA has authority under the Clean Water Act to issue orders like this, and if they have authority under the Clean Water Act, whether that's actually constitutional. The specific issue being the Sacketts had no right to challenge this order, and that's what concerns everybody. They had to wait for EPA to decide that the Sacketts were either in compliance or a fit subject for the heavy hand of government enforcement. And the penalties for violating these orders are quite large. They are indexed. They're currently at $37,500 per day. And one of the issues in the case, the Sacketts having to wait for EPA to decide whether to enforce or not, are subject both to a $37,500 a day penalty for violating the Clean Water Act, and a separate $37,000 penalty for violating the order that EPA had issued.
I see. You know, this case specifically applies, of course, to that Clean Water Act. You know, is it possible that if the EPA loses this case and you know, loses its enforcement authority, does it have a broader impact than just under that Clean Water Act?
Yes, that's exactly why everybody is interested in this case. In fact, the interesting thing is EPA issues most orders, statistically, I think, under CERCLA, the Superfund law. And their authority to issue these types of orders under the Superfund law has been challenged a number of times. And GE, in particular, has been on this issue for a while. And they had brought a case in which they had sought cert from the Supreme Court, and the Supreme Court had denied cert just a month before they granted cert to the Sacketts. Some people are speculating that an individual husband and wife make a more sympathetic plaintiff against EPA than GE, perhaps. But there is certainly concern, I'm sure, at EPA that if EPA loses this case, it would have much broader impacts than just the Clean Water Act. Every statute is different. The Clean Air Act is discussed specifically in the Sackett case before the Court of Appeals, and the language in the Clean Air Act is almost identical to the Clean Water Act. It is very unlikely, if EPA loses before the Supreme Court in Sackett, that their unilateral authority under the Clean Air Act would survive. CERCLA is a little bit different. The statutory language is different, and I can talk about that. But it is possible that the Supreme Court could issue a ruling that would require EPA to grant pre-enforcement hearings for its order authority under the Clean Water Act and probably the Clean Air Act without affecting its authority under CERCLA. And that's really, next to whether the Sacketts win or lose, that's the big question, is would the decision be broad enough to sweep in CERCLA as well?
I see. And looking back and kind of looking forward at the same time, what's the history like on the influence of cases like this? And does this really have the potential to be as impactful as it seems? It
does. The case has a potential to have a very big impact just on its own terms, again, if EPA's authority is limited. The concern that everybody has had, even though if EPA takes enforcement action, people can then defend themselves, is that EPA has a lot of coercive authority. And when people, and not just small husband and wife like the Sacketts, but even large corporations like GE, get an order from EPA, it's very hard to say no. Because you don't, to take a chance that 2 years later, after all those penalties have accrued, you're going to get a decision in your favor. It's really rolling the dice, and most corporations don't like to roll the dice, and individuals don't like to roll the dice. The broader question about the impact of the case is whether anybody will pay attention, particularly the lower courts. And I think that's what you're getting at, and that's a concern that I've noted and others have noted. If the case says that EPA cannot issue these orders without a hearing, without violating due process, that's pretty clear, and the lower courts will follow it, and EPA will grant hearings. If they don't, then at least for CERCLA, which is again where most of these orders are issued, it won't be totally clear what the impact is. And they could issue an order, and again, most lawyers know this, some clients know this. The Supreme Court tries to avoid constitutional interpretation if they can decide cases based upon a statute. And so they could issue a decision that doesn't explicitly make the constitutional finding. It's therefore not explicitly covering CERCLA, but there could be language in there that's pretty strong, and everybody could look at it and say, EPA's lost its authority under CERCLA. But EPA could say, no, they didn't. That's all dicta. We still have our authority. And then you go back to the lower court, and I have seen, at least from my perspective, a pattern where the lower courts simply, and I say this rhetorically, but it's partially true, the lower courts rule for EPA because it's EPA, and they say we're enforcing the environmental statutes and we're protecting the public, rule in our favor. And sometimes, that's the way it feels from my side of the table anyway. And there have been a series of cases under Superfund in which the Supreme Court has said what seem to be some pretty clear things to EPA about limits on the liability scheme under CERCLA, for example, which EPA has simply ignored, and they've managed to persuade lower courts that the Supreme Court couldn't possibly have meant what it really meant. And you have to wait then for a few more years, hopefully for the Supreme Court to take another case and say, yes, we really did mean it. And that could be the situation here as well. There's language in the oral argument transcript for Sackett in which, for example, Justice Alito says, you wouldn't think this could happen in America. It's really language like that. They can't believe it. This is just unfair and outrageous, and I think to Justice Alito, plainly unconstitutional. But it's not obvious that the decision will be that plain, and then we'll see what EPA does and what the lower courts do.
It's going to be an interesting one to watch. This has a huge, huge impact in the realm of environmental law. Once again, that's Seth Jaffe, attorney at Foley Hoag and author on the firm's blog, The Law and the Environment. For more on this story, be sure to visit lawandenvironment.com and, of course, lxbn.lexblog.com. Thanks, Seth.
Thank you.